So thanks for having me here today. I am delighted to get a chance to talk with you all about lie detection and memory detection and what some of its implications for law are. By way of a little bit of background, I look at the implications for emerging neuroscience and genetics for constitutional law if we actually get to the point where this evidence is relevant. But I'm also doing another piece, which I'll talk to you about at the end, which is an empirical analysis of how neuroscience has been used in the criminal courtroom, in particular by criminal defendants. And what's interesting about this conversation that we're having today and what we've been having over the past couple of days is, of course, it's here. And I'll show you some of the numbers which come from just a tiny subset of the cases that we can have access to that show how dramatically it's shown up in the courtrooms, but also that issues with respect to memory and lie detection in neuroscience have shown up in the courtroom. So we're going to talk about a high-tech and sophisticated version of doing so, but I'll show you at the end kind of low-tech neuroscience that's already showing up. So it provides an interesting dichotomy with how some of it's being treated. So there's two questions that I think are important to ask when we're dealing with fMRI, lie detection, memory detection, all of it's part of a continuum. The first and most important one, of course, is, does it work, right? And that's where we have to start and end right now our inquiry, because the answer is it doesn't work well enough for the most part for use in the criminal courtroom. And if we start with fMRI-based lie detection, we can see that there are a number of problems with it. So what is it? The idea is that if we ask a person a series of yes-no questions, that there's a different area of the brain or different areas of the brain that light up when you're being deceptive than when you're being truthful. And different companies have claimed different regions of the brain are implicated, so there isn't consistency as to which regions those are. And some theories, which are consistent with earlier versions of lie detection, they argue that what's really happening is it causes a lot more conscious processing, a lot more work to lie than to tell the truth. And given that all of that's happening in your brain physically, we can ask you questions and see, does it require more work for you to lie than to tell the truth? I think Judge Duffy raised the question about what about psychopaths? That was maybe it was somebody else in the room, but the question of psychopaths, they look different, in part because it's really not that hard for them to lie. And given that it's not that hard for them to lie, it might not be that hard for some other people to lie too. So there's some problems with the measures. But there are at least 6 problems with the studies right now, which mean that where we are right now in this yes, no, maybe is probably no. One of those is most of these studies have tiny n's, meaning that there's a tiny number of people who are enrolled in these studies, so we don't really have broad enough, reliable enough information yet from broad studies to know whether or not this actually tells us about lies or truths. The second is there's been problems with replication of these studies. So there's been disparate replication. Some of them have not been replicable at all, which is a serious problem when you're talking about scientific evidence. That's one of the gold standards, is can you replicate the thing? Third is it's a pretty homogeneous group, right? So if you're doing this on a college campus and you're drawing undergrads who are psych majors who claim that they're not doing drugs, that's a pretty homogeneous, right, looking group of individuals. And so, you want some variability when you actually have people in a study. There's differences in the regions of the brains that people claim are implicated. The countermeasures that Anthony talked about for memory apply equally in this area as well. You can easily fool a machine. Anthony mentioned I could tell you personally about that. Anthony subjected me to cruel and unusual punishment and had me in his machine for 2.5 hours. And I did quite well on the explicit memory recognition. I think it was 70 to 80%, I can't remember exactly. But I do know that when he said employ countermeasures, and he didn't instruct me how to employ those countermeasures, he just said just figure something out. So I'd see a face and I'd be like, no, I don't know that face, even though I did. And I would, conjure up an image of somebody who I knew well and just kind of come up with different strategies. Or I would focus on just a different point in the image that was shown to me, just down in the corner, something I'd never seen before, like, wow, I'd never seen that speck before. That's so interesting, that little speck there. And just by having that thought process, it took me down to 50%, just chance, right? So the same test done differently can easily be beaten. And if we're talking about people being in fMRI machines and being taught how to do so, they can change their baseline quite easily. And then the last one is it really lying that we're testing for, and is it the kind of lying that we think about in the real world. So if a study says, okay, I want you to lie about whether or not you stole the ring or not, okay, so just an example from one of the studies. And if you succeed, you get $20, right? That's very different than somebody actually being on trial for their life, and it's a lie that's a real lie, right? Something that they've really told. So let me just try a little something for you. Just take a look at my outfit. Do I look fat? Any man in this room who looks, shame on you. Surely your wives have taught you something about not looking, but we lie all the time, and that's just a small lie, right? Surely all the time you say, like, no, honey, you look fabulous in that, right? Or like, no, of course that, how could it make you look fat, right? There's some answers I'll give you if you need them, just as like pocket answers to have. But we lie every day, right? And we have small lies and we have big lies, and the nature of the lie may matter quite a lot. And we can't do real-world studies right now of fMRI, so it's really hard to be able to differentiate between a real lie, one where your liberty is at stake, versus that tiny little lie. So, what's happening right now is, for the most part, it has been held inadmissible. And I'll talk about some of those cases in which it's actually happening. Just to give you one more little example of this, which is it really a lie? This is just something I thought was great to get you in the mood of thinking about different lies are different. You're not going to be able to hear it. Well, you might be able to see it anyway. You might not need noise for this. Oh, here we go. Now, that just gives you a sense, right? There are very different kinds of lies. This is a joke, but you can imagine infidelity lies are going to be very different from a lie about, did you shoot your wife, or did you cheat on that test, right? And if we're trying to figure out whether or not deception looks the same, it might be just, foolish for us to think that all semantic representation of every type of lie is exactly the same, right? Is this lie going to look the same as your little lie about, no, Nita, that looks fabulous on you, or the lie about whether or not you actually were involved in a homicide or a robbery? But should fMRI lie detection be used today? So, the admissibility reasons are probably enough reason to say no, but that doesn't answer for us if we ever do get past these ecological issues, which we may, right? I mean, the science is getting better every day. What then, right? What if we get past it? So I'm going to start by telling you just a little bit about several attempts to introduce fMRI-based lie detection in the courtroom before turning more broadly to memory and lie detection. And you might say that the 3 attempts that I'm going to tell you about have been epic failures, maybe not as bad as these scuba divers, if you can't see what's happening there in the background. Although Owen Jones, who likes to go diving regularly with sharks, will tell you this is no problem at all. So maybe not an epic failure. But to give you a sense of what's happening, this is one company, which is Lie MRI, and they claim to have, really, that's their name. It's, the other one's a little bit better. It's called Sappho, but Lie MRI has decided to just be honest about what they're doing, right? Not actually try to hide it behind any sort of scientific words. And they have what they call as new truth verification technologies, that they provide an unbiased method for the detection of deception and other information stored in the brain, and it represents the first and only direct measure of truth verification and lie in history. Very exciting. And what they show here is these different regions of the brain. They say this is a lie versus this is a truth. So if you see the red regions lit up, they say that's a lie. And if there's a blue region lit up, they say that's a truth. I mean, that'd be fabulous if that was actually the case, but as I mentioned, there are a lot of problems with this. Lie MRI and Sappho have been involved in a couple of different cases, and I'll tell you about them. So the first one is a case called Wilson v. Corstaff, and here the lawyer wanted to use fMRI lie detection evidence to break a he said, she said dispute, right? And these he said, she said disputes are, we see this all over the criminal courtroom. If we could figure out who's actually telling the truth and who's lying, it'd be fantastic, right? Well, so in this case, what happened was the plaintiff said that after she complained to a temporary agency about sexual harassment at her job site, that what happened was that the supervisor said, okay, don't put her on anything good anymore, right? Make sure that she's marginalized, don't give her any good jobs anymore. And she also says that she has a witness to this, that witness is somebody who is a fellow employee, and that fellow employee actually heard the supervisor say that, this person shouldn't be put on any good jobs anymore. So retaliation is her claim for sexual harassment and for reporting the sexual harassment. And she says, look, here's evidence. I've got this guy. I want to put him into an fMRI scanner and show you the data that shows he's telling the truth when he says that the supervisor said these things. And of course the supervisor says, no, I didn't say anything like that ever, right? But they don't have access to that guy to put him into the fMRI machine. So they want to introduce this person and say this person's brain proves the truth. And in a pretrial motion in limine, the judge held that the evidence was inadmissible for two reasons. One, and the primary reason that the opinion focuses on, is that judgments about credibility are solely within the province of the jury. That the expert doesn't provide anything expertise that the jury doesn't otherwise have, that an expert's job is to bring in expertise that the jury doesn't otherwise have access to. Credibility determinations are something that the jury does have access to, so you don't need this evidence. And then the last line of it said, but anyways, even if that isn't a good enough reason, there's a lack of any sort of general acceptance under the Frye standards, so that's a good reason enough for me not to include it in this case. A little while later that year, in United States v. Samaroo, prosecutors claimed that Samaroo, who was a psychiatrist, had sought to defraud Medicare and Medicaid in the way that he contracted and billed for his services. And he argued that he had no intent to defraud the government, and the government has to prove intent to defraud, right? So what happened is he has, his attorney says that the president of Sappho has actually put him through a number of fMRI scans, asking him a series of questions, breaking it down between the two main types of fraud that needed to be proven. And that on both of those, he did really well. Well, there was one small problem, which is on the second scan, the first time they did it, which was later in the day, he actually failed in that it showed that he was deceptive. They decided that can't be right, so they decided to repeat the scan another day where it showed that he was telling the truth, because he must have just been tired that first time, not actually otherwise. So that was a problem for them in the case, of course, but that wasn't the only reason. So a very detailed opinion was issued in this case where the court said the fMRI evidence can't be introduced. And the reason was threefold. First, under Daubert, which was a pretty detailed Daubert analysis, saying that there was an absence of real-life error rates, that there was no controlling standard, and the apparent deviation from the protocol to actually repeat it a third time was problematic. In fact, that begs the question of what would have happened the fourth time they ran the scan. Would it have shown him to be deceptive? So all of these were problems. But also, under Federal Rules of Evidence 702 and 403, the court said it should be excluded. So for all three of those, in a very lovely and detailed opinion, the court goes through and explains why it shouldn't be admissible. I'm really bad at pushing the right button, apparently. All right, then this last one that Anthony mentions to you is Gary Smith, who was charged with depraved indifference homicide in Maryland, and in August 2012, he sought to introduce fMRI lie detection to prove that he was telling the truth when he says that he didn't kill his roommate. And a consultant was hired for no lie MRI, and the expert was brought in and opined that if Smith chose to testify, he'd be asking the jury would like to know things like, did he shoot the victim? And obviously he'd say no, but the jurors would get to see things if he chose to testify, like, was he sweating or not, right? What was his affect when he was actually telling his answers to those questions? Did he appear nervous as he was answering those questions? And they would make judgments of his credibility based on those pieces of information. So why not this additional piece of information, which was his brain scans about whether or not he was telling the truth or lying when answering questions? And the Maryland court, using the Frye standard, ruled that fMRI can't be introduced because it has not yet reached scientific consensus about real-world lying, right, which is different than laboratory lying. So it was hard to know whether or not he was actually telling the truth. Interestingly, looking through these different opinions and seeing some of the things that were answered, they're asking individual questions like, did you shoot your roommate? But when asked whether or not they can predict on any specific answer whether or not a person is telling the truth or lying, they can't. It's a general impression overall, is the person lying or is the person telling a truth, rather than being able to tell you on any specific question whether they're lying or telling the truth. So that's another problem for all of this. But that just gives you a little bit of the history. It doesn't answer for you the question of, if it does work, then what, right? Because we may get past these ecological issues, so if it does work and admissibility isn't the end game, what are we going to do? And let me tell you a little bit about the conundrum that I see, starting with DNA cases. So with DNA cases, I have looked into and asked, and many of you have thought about and been confronted with, how are you going to deal with Fourth and Fifth Amendment issues that arise when DNA is collected from an individual? And if it's shed, for example, on a water bottle and it isn't collected through a swab by an arrestee, how is that information treated? And for the most part, we say there's no Fourth Amendment protection here because it's shed, it's abandoned, there's no property interest that remains in the thing that's left behind. And there's no Fifth Amendment interest because it's real physical evidence, not testimonial evidence, so it can be used against a person. There's no constitutional problems with doing so. Does that tell us anything about how we're going to deal with brain-based evidence? Right? Because this is physical blood flow in your brain. You don't have to respond, you don't have to testify, you don't have to do anything other than lie there. It's not invasive, it's not physically invasive. So what are we going to do with this? Is this something like physical evidence? Is it something like testimonial evidence? It isn't clear exactly how we'll do with it. So to be a witness under the under the Fifth Amendment, as it's currently understood, is largely based on this idea of the difference between real evidence versus testimonial evidence. In Holt v. United States, the court said that there was a prohibition on the use of physical or moral compulsion to extort communications, but that doesn't exclude bodily evidence. And in Schmerber v. California, when Schmerber went to the hospital intoxicated and they wanted to take a blood sample from him in order to use it against him to prove that he was intoxicated, the court said there's no Fifth Amendment problem with that because that's real physical evidence. There may be Fourth Amendment issues, although not really. It's not unreasonable because it's a safe, easy, ordinary medical procedure to take a little bit of blood from an individual. So if that's the case, real physical evidence is different than testimonial evidence. How are we going to deal with all of this? And it seems like there are three kind of main categories that exist in current Fifth Amendment doctrine, which is there's physical evidence, and that's things like the use of the body to incriminate a person, like their appearance, their footprints, their voice prints. Even private parts can be seen, such as strip searches and body cavity searches, and that's all physical evidence. There's this weird little category of quasi-physical evidence, which is physical functioning and traditional lie detection tests, which hasn't been resolved, and I'll talk a little bit more about. And then the last category that is protected by the Fifth Amendment are things like communications or the productions of paper, but not the papers themselves, all of which may have interesting implications for us as we think about memories and lie detection. So a couple of unsolved riddles. This right here depicts my version of what's happening in a case called Estelle V Smith. And in Estelle V Smith, there was a compelled psychological evaluation of the defendant. And during the compelled psychological evaluation of the defendant, the psychiatrist noticed a number of ways in which the person was responding to questions about the crime. And it was physical twitches in the face and little things that just showed what the psychiatrist believed were the reactions, which were very telling. And he introduced that evidence during the sentencing phase in order to support his opinion that the person was likely to be a future danger to society. The court said, well, the compelled psychological evaluation is perfectly permissible, and we don't know about this using the physical functioning of the person's body in order to inform even sentencing, but we're not going to worry about it yet because the science doesn't seem to be good enough. Okay, but that functioning, that physical functioning, is a lot like what we're dealing with in the brain cases. Oops. Really just don't know how to do that. In this lie detection case in Schmerber v. California, the court did talk about lie detection. And what they said was that lie detection, which measures physical changes in the body to make inferences about a person's responses to questions, might implicate the privilege against self-incrimination, but they don't know yet, and they don't have to worry about it yet because the science isn't good enough yet. So maybe it would, because it's actually trying to measure responses, right? So this quasi-physical category maybe applies. So thinking about this, the functioning of a person's body, which is just like the blood flow in their brain, or the responses, using the body to gauge responses rather than the voice, this might be quasi-physical evidence that isn't clear. And just a couple of other unsolved riddles, it's clear that the police can gather business records from an individual, but the act of producing the records themselves can't be used as evidence against a person if that gives new information, right? Because the act of producing evidence says, I have it. I know of its existence, and therefore, if they use that to show that the person has knowledge and awareness of its existence, that itself may be protected, but the substance of the information is not, which is the reason why there's a circuit split over whether or not private diaries and writings are actually protected, because it's something special about your thoughts being captured in this area, right? So is it protected? Is it not protected? And there's a heartbreak exception that some circuits have that say it would break the heart of the Fourth Amendment if we allowed diaries to be used. Well, I don't know what the heart of the Fourth Amendment looks like, but the other circuits think that it's just fine. It doesn't affect the heart whatsoever. All right, so what does all that have to do with memories? So Anthony talked to you a lot about recognition memories. What is a memory, right? Assuming we can get to it, what is it? Is it like your diary, where we have no idea whether or not it breaks the mythical heart of the Fourth Amendment? Does it matter the way in which we obtain the information from you? Would it be protected by the privilege against self-incrimination? If a criminal suspect is asked something, for example, like, do you recognize this person, and that person is the co-conspirator in the crime? Or there have been other studies where there's neural fingerprints that are associated with specific speakers or specific sounds. So you have on recording the person saying, let's go to the other person, but a fuzzy image of their face. And you play the let's go for the person and see recognition in the brain. Can you use that as evidence against the criminal defendant to show that there was a recognition memory in their brain? Remember, it's just blood flow patterns. You're asking the person, they're sitting there silently. There's nothing invasive physically that's being done to them. This right here is kind of extraordinary technology. I don't think anybody's talked about Jack Gallant's work, have they? So one of my very favorite neuroscientists, no offense to anybody in the room, is Jack Gallant over at UC Berkeley. Now, you might not think these two things look that similar, but let me tell you what he's doing. He is using pattern recognition algorithms to try to figure out the visual imagery in your brain. So he shows people a series of film clips, and the computer gets to see your fMRI brain images that are generated as you're watching the videos in the film clip. And as you're watching those videos in the film clip, you get to see what's happening, and the computer gets to see it as well. Now show the person a novel video clip and have the computer predict what the person's seeing. And this is what is reconstructed just using the first few voxels in the visual cortex. And as you go further back into the visual cortex, you get additional details, like you have clear lines rather than blurring, and you get to see more about colors and images. So this is reconstructed, and it's not a still image, it's actually a moving image that they're able to reconstruct from the brain. And again, this is from the same study showing you what they reconstructed versus what the person saw. Pretty amazing if you could actually reconstruct that kind of stuff from a person's brain. And in case you think, well, they're seeing it, it's not that cool because they're actually getting to see something. This study came out this week where when a person imagines something, okay, you're not shown an image, you just imagine it, they're able to likewise see particular neural patterns associated with the different personality profiles that they gave to individuals. And I'm not going to go into this because Francis is over here telling me I'm running out of time, but it's pretty cool to think not only can you reconstruct what you're seeing at the time, but also what you're imagining. And Jack's most recent study reads stories to individuals and tries to reconstruct what they're hearing. And he's able to now do semantic language reconstruction, and not just what you're hearing, but what you're imagining. Okay, so what does all that mean? It means thoughts, memories, what you're actually saying potentially could be reconstructible. What are we going to do with all of that? So all of these kind of utterances, the only one I'll talk about for the last couple of minutes is just, truth-telling, back to this, kind of idea of utterances. What is this? Is this something protected by the Fifth Amendment or is it not? And is it protected by the Fourth Amendment? Well, I think probably not, and you have in your reading packet a couple of articles from me, one of them on the Fourth Amendment, one of them on the Fifth Amendment, and that's because we generally deal with Fourth Amendment issues based on your physical intrusion into a physical space, right? We measure the interest that an individual has based on the degree of violence done to that person, the degree of violence and intrusion into their physical space. But information itself doesn't seem to be protected, right? Information itself is not what the purpose of the Fourth Amendment is. It's to protect people against intrusions upon their seclusion, not intrusions on their secrecy. And so if that's the case, then this technology enables us to do it easily, simply, without any kind of harm to the person. It doesn't seem like the Fourth Amendment will have anything to say either. So I want to close by showing you one thing, which is this. So this chart is the empirical study I was telling you about, which is the number of cases in which neuroscience has been discussed in a judicial opinion. A couple of caveats. One is when you write an opinion and it shows up in Westlaw, I code it, okay? And if you say the word neuroscience or anything close to it, it shows up here. But this is cases in which a criminal defendant has introduced neuroscience on their own behalf. And you can see the numbers were, I thought, impressive in the first few years I was doing it, 2005, 2009, like 100 cases, 205 cases. Remember, about 10% of criminal cases go to trial. Of those 10%, maybe 1% end up on appeal. Who knows how many Westlaw actually includes in its database? So in that tiny little snapshot of the world, this is what we're seeing. These are shaded because I haven't twice coded them yet. But 2010, 322, 2011, somewhere around 1,400, 2012, somewhere around 1,700 cases. And interestingly, a number of those cases deal with memory. And they deal with memory by things saying like a defendant saying it was ineffective assistance of counsel for failing to investigate my impaired memory using neuroscience, okay? Or I pled guilty improvidently. I had hit my head before I came into the police station, and here's the neuroscientific evidence that shows I didn't have the capacity to have a good enough memory of the circumstances that led up to it to justify doing so. Or you should toll my failure to file on time because I couldn't remember what the filing date was because my brain made me do it, right? And in these cases, it has actually been admitted, right? So there haven't been big Fry hearings and big Daubert hearings and big, hearings excluding the evidence based on admissibility. It's brain damage evidence largely rather than fMRI brain functioning. But what's the difference? If we're enabling memory detection and memory credibility determinations based on neuroscience already, are we really going to have that admissibility hurdle be the only hurdle that will prevent us from having fMRI-based lie detection or memory recognition? All right, so with no further ado, let's have a conversation. Thanks.